The Senate will have the final say in the impeachment proceeding of the president, which can only pass if the 2/3 or more of the senators support the impeachment motion from the parliament. So basically what we are saying, an impeachment motion has to be adjudicated at the Senate. The trial has to be done at the Senate. So the parliament, what they do, they form the articles of impeachment, they come up with the reasons why the president needs to be impeached or be removed, and then now they submit that to the Senate and they come and argue the case. So those who are for the impeachment will argue the case why the president should be impeached. Those who feel like the president should not be impeached also argue the case in front of their 100 senators. And then now the senators will make the final decision if the president will be impeached. So according to our number, we will have a 100 Senate, 100 member Senate. So basically, for a president to be impeached, senators have to vote 60 of them for that particular impeachment to pass. So if they don't vote 50, or if they don't meet that 60% threshold, then the impeachment will fail. And then also we are saying all judges will be vetted and confirmed by the Senate. So basically what we are saying is, after the senators have confirmed a judge, it's only a ceremonial duty of the president to have them sworn in. But if the president refuses to swear these judges in after 14 days, then the Chief Justice will be mandated to swear in the judges and for them to take the responsibility immediately. This is very important for us because we want the separation of powers between the legislature, the executive, and the judiciary. We cannot have powers held by the executive holding the judiciary hostage. So we have to make sure that the legislature can be the arbiter in between that issue. Members of county assemblies, we retain the 1,450 wards. We add 750 party list MCAs to be distributed per county election numbers using a national quota system, where we have the total valid votes cast divided by 750. Then subsequently, through party election results, in consideration of the first past the post election of singular wards, then we will have a total number of 2,200 MCAs across the country. No single party should hold more than 70% of county assembly seats. In case a party wins more direct seats through wards, then they automatically are not eligible for party MCA list. This is to ensure majority and minority representation to the county assemblies to come from different political parties and coalitions. So basically what we are saying is, we retain the 1,450 wards, we remove the nominations at the county assembly level. So then the 750 number of MCA list will be distributed to the counties according to the total vote cast divided by 50. So we'll have a quota system for MCAs. So when you use the current number of election results that we used in 2017, you use the total valid votes cast divided by 750. It will come to around 20,000 votes. So basically, one MCA will represent 20,000 seats. So for example, in Homa Bay, if you have 400,000 voters, you divide that number by 20,000, you will get around 20 seats or 20 to 30 thereabout seats. So those are the seats that will be allocated to Homa Bay County. And that is done by the IBC spread across the counties. And then now, these numbers, once they are given to the counties, they are going to be distributed according to the party's performance, the party vote that was declared by the county returning officer at the county level. So we also want to make sure that the majority and the minority parties come from different particular political associations. So for example, if a political party wins 75% seats of that particular county, then the 25 will be allocated to another political party or coalition. So what we are just trying to make sure that we have to correct this anomaly in our representation at the county assembly, where you find political parties win 100% of these seats, like places in Kirinyaga County, Homa Bay County, where you find ODM wins 100% seats, then they come and sit down in some corner and decide that now this team of ours will become minority, these ones become majority. The minority party and the majority party have to be different. So we have to make sure that the majority party, if they win a lot of seats, direct seats through the wards, they are not eligible to be able to be given MCA party lists. On IEBC, we are advocating for 9 commissioners of the National IEBC Council. The commissioners to be members of the Law Society of Kenya and have a background in legal affairs. We strongly believe that the commissioners should be nominated by the judiciary, that is 3, the religious society 3, and the civil society 3. Political parties must not be allowed to nominate any commissioners due to impartiality and party allegiance. We must protect the sanctity and the credibility of the electoral process. We advocate for local and national elections should be held separately. Local elections first, that is the governor elections, the MCA's elections, and the senatorial elections. We also expect a party vote at that elections. And then later the national elections, that will be the presidential election, the members of parliament elections, and the party vote. So time we can be able to have an agreement with other stakeholders and agree upon. But as we are suggesting, one to be done in August and the other one to be done in December. On independent institutions, there should be more autonomy and separation of powers between the executive and the various independent institutions. We advocate for more powers should be assigned to these institutions for them to be effective and efficient. We advocate that the office of the DPP should be funded adequately to enable it hire more economic crime investigators and more public prosecutors to aid in fast-tracking prosecution of corruption and economic crimes. The institution's head should go through a Senate confirmation before appointed by the President. The heads should also enjoy security of tenure to remove efforts of blackmail, intimidation, interference by other arms of government. Basically what we are saying is that the heads of these independent institutions, because our democracy depends on them, we want these heads of these institutions to have security of tenure. And also too, we want them to have so much powers in such a way that they can be able to discharge their mandate efficiently and effectively. And we also expect that the executive shall not have any undue influence on the nomination and the confirmation of these particular heads of these independent institutions. We expect the Senate to have the final say, and once somebody has been confirmed to be the head, for example, of the DPP, Director of Public Prosecutions, we expect that person to discharge their mandate for 10 years without being worried about what the President or the Prime Minister feels. They should be able to do their job accordingly without worrying that they can be removed from office from powers in the executive. Political parties. We are suggesting that political parties that do not win any elective post from the MCA level to the presidential level in 2 electoral cycles of participation should be deregistered. Basically, what we want to do is we want to make sure that our political parties do their mandate. They do their responsibility of entrenching our democratic ideals. So we don't have to have all these political parties that don't do anything. They don't win seats, they don't compete, they don't nominate, they don't do anything. So basically what we are saying that every political party should be given 2 electoral cycles. If they cannot be able to win even a single MCA seat, any seat on the electoral process that we have, in 2 electoral cycles, then they should be deregistered, so that we can be able to also deal with that particular issue of a lot of political parties that don't do anything. And also this will also entrench and strengthen the office of the ORPP, Office of the Registration of Political Parties. The judiciary. The powers of the President in the confirmation of judges should be diluted and made only ceremonial. The President has the power, but if the judges are not confirmed in 14 days, the Chief Justice should effectively have them sworn in to ensure performance and optimal functioning of the judiciary. Then in the principles of separation of powers, the powers of the executive and the legislature should be diluted to protect the judiciary from undue influence from the other arms of government. The judiciary budget should be determined by the JSC, the Judicial Service Commission, and cannot be amended by Parliamentary Budget Committee. So basically what we are saying is the judiciary, we've seen concerted attacks on the judiciary. So in the spirit of separation of powers, judiciary should have their powers. One, we've seen one line of attack is funding of the judiciary. So we make sure that we transfer that power to the Judicial Service Commission. So the Judicial Service Commission will come up with a judicial budget on how effectively the judiciary can function. And then they will submit this budget to the Parliamentary Budget Committee. So the Parliamentary Budget Committee cannot alter, but what they can do, they can give suggestions and amendments back to the Judicial Service Commission for them to take in charge, so that they can be able to have a one moderated budget that will be approved by the legislature. And two, on appointing judges, we want the power of appointing judges to be removed from the president. It should only be ceremonial. The judges should be confirmed by Senate. Once confirmed, the president is expected to have them sworn in after 14 days. If the president fails to do that, then the Chief Justice should have them sworn in immediately to ensure optimal functioning of judiciary, and also to make sure the judiciary is not held hostage by the presidency or by the prime minister's position. On corruption, witness protection should be reviewed and the witness protection agencies strengthened to protect corruption witnesses and whistleblowers. There is also need for civic education to enhance public awareness on the availability of witness protection agencies. Introduce stiffer penalties for corruption crimes such as life imprisonment, hard labor, compulsory recovery of corruption proceeds, and barring the corrupt from holding public office or elective office for life. Corruption should also be made very expensive, less attractive, and painful. Appointees to key governance institutions should be thoroughly vetted, and applying for a public position while still having a corruption case, one should be barred. Public sector employees should declare their wealth. Failure to declare ownership of assets should amount to forfeiting the same asset to the state. And the cost incurred in investigating the ownership of the undeclared asset will be borne by the violator of this provision. The wealth declaration forms should go beyond mere declaration of wealth to explaining how the wealth was acquired over time. The independence of governance institutions should be strengthened, especially those institutions dealing with prevention, investigation, prosecution, and adjudication of corruption. Government employees and elected officials must not do business with the government. This is to avoid conflict of interest and the temptation for corruption that often arises from strong intertwining of policies, politics, business, and kleptocracy. We must adopt a single agency model of fighting corruption as opposed to the current multi-agency approach. In this regard, one institution should be responsible for all corruption-related cases, from the investigations to convictions. We therefore want the EACC to be disbanded immediately, so that the DPP is officially empowered to deal with corruption-related cases and other crimes. The DPP should also be the enforcer of Chapter 6 of the Constitution on leadership and integrity. We are advocating that the EACC should be a department under the Office of the Director of Public Prosecutions. This statement has been issued by Michael Rapudo, Party Leader, Democratic Renaissance Alliance. Thank you.